So what happens if you get arrested? Okay. When you are arrested in Montgomery County, Texas, it doesn't matter which agency has arrested you. They're going to end up taking you into the custody of the the Montgomery County Sheriff's Office. You're going to be taken to the jail in downtown Conroe. You may get taken to a satellite location first if you're in the Woodlands or out in East County, what we would call the New Caney area. They're going to take you to jail. You're going to see the judge in the morning. Typically, you're going to stay overnight. If they have set a bond for you already, like you have a warrant or something like that, you can call a bondsman and do what's called an in and out. It's not real quick. It can still take hours of being in jail, but they can uh, update the process where you don't have to wait to see the judge. But let's say you get arrested, you're pulled over for speeding, you've got a vape pen in your car, they're going to arrest you for possession of a controlled substance penalty group 2, and then take you to the jail. The next thing that'll happen is when the judge sets your bond, you can then make that bond. You can have a family member or someone call a bail bondsman and help them pay for typically 10% of the value of your bond. So if you have a $3,000 bond, you probably end up spending around $300 with a bonding company. You can also pay what's called a cash bond, which is where you pay the full amount. Let's say it was a $3,000 bond. You would pay the full $3,000 at the jail. And then at the end of the case, when it's resolved, win, lose, or draw, you will get that full 3,000 back. If you go with the bondsman and you pay 300 to a bondsman, you're not going to get that 300 back, but you don't have the potential of losing out on the full 3,000 if for some reason you don't make your court date. Okay. So if you have a felony or you have an assault family member case misdemeanor, or you've got a DWI with greater than a 0.15 breath alcohol, any class A misdemeanor or felony offense in Montgomery County requires what's called bond conditions. Bond conditions are when you're basically on probation before you've been found guilty. This is a big frustration for a lot of our clients. It's something that every case in Montgomery County has. It is very unlikely that the judge is going to remove bond conditions if they've already been set. In a felony case, even if it doesn't relate to using drugs or something like that, let's say it was an evading in a motor vehicle case, the judge is still going to want to drug test you, alcohol test you. You're not going to be able to consume alcohol or drugs on that kind of a probation or bond condition. Okay. This can be especially difficult in family violence cases because part of the bond conditions and protective orders are that you may be kicked out of your own home. And it's going to be a process that we need to work on as a criminal defense attorney in order to get those things changed. It can take weeks, sometimes months, and it's a very frustrating process. Obviously, this isn't a great process if you're watching this video and wondering what is going to happen when you get arrested. These are some of the things that can happen. You're going to have court dates, okay? After you get situated with the bond conditions, maybe you can go home. You're eventually going to be given a court date. You have got to appear at that court date in person for every type of case other than a Class C offense if you have a lawyer. If you don't have a lawyer, you're going to have to appear in person on the Class Cs too. But anything that you've been arrested and taken to jail for, I would assume you're going to have to be there at that court date. If you're not there at your court date, you could have your bond revoked, end up back in jail, having to pay another bond. And then finally, case resolution. Now that's where the meat and potatoes of what your lawyer is going to do for you comes, is in between the court dates and resolution of the case. There may be some work on the bond conditions. Most of the time, those are going to stay pretty static in Montgomery County. On the resolution, that's where your lawyer can look at the evidence in the case, can review things from a legal perspective, talk with you, receive affidavits, submit those things to the DA's office, and try to work out either a plea bargain through negotiation, get a dismissal if there's not proof beyond reasonable doubt or the police have made some legal error in collecting any of the evidence. And so that is where all of the work that the criminal defense attorney does to help you. Let's look at the next slide. So here we go. This is what you need to know about Montgomery County just to start, okay? It is tougher on crime than surrounding jurisdictions, especially more so than Harris County and Houston. It's a different makeup. It's a different group of people here. It is less urban. It's more country. It's more suburban and it is more conservative. It is one of the most conservative counties in the state of Texas, and the prosecution and the district attorney's office is tougher on crime, especially higher end felony and violent crime than in other jurisdictions. So, just right off the bat, if you've got a case in Montgomery County, it is probably a little bit more serious. It needs to be taken more seriously than if it's in another county. Again, we've got that more conservative population, but not only that, there's just less crime overall happening day to day. I used to be a prosecutor in Montgomery County and in Harris County, so I've seen the level in both places. So we would work what we call a 24-hour intake shift, and it is not, you don't work all 24 hours, but somebody at the DA's office will work all the time, and police will call in to determine if they have enough information to arrest a certain individual. Okay, we would get an aggravated robbery in Montgomery County something like once every 3 months or so. We were getting 2 and 3 a day in Harris County. Okay. So just the fact that the prosecutors don't see these serious cases as much, it makes them prosecute harder because every prosecutor is looking to, take the big cases and make an impression on those big cases. Well, if you have 400 of those assigned to you at one time, like you might in Harris County, the lower level ones, you're going to treat a lot differently. You're going to be more lenient on. In Montgomery County, every one of them is treated with very high seriousness just because they have fewer overall and they can devote more resources to it. What are the common misdemeanor crimes that are filed in Montgomery County? Well, probably one of the most common, two most common, I think, are DWI and possession of marijuana. DWI is driving while intoxicated. This means that you've either got an alcohol concentration of 0.08 or more, or you have lost the normal use of your mental or physical faculties because of the introduction of a drug or alcohol, and you're operating a motor vehicle in a public place. Okay. That is the most likely crime because it is a crime that anybody can commit, and you don't have to make a whole lot of conscious decisions to end up in that position. It's a crime that can happen by mistake a lot. And so I'd say that's probably the most common. The next most common is possession of marijuana. And I know what you're thinking if you know somebody who's been arrested for this is, are we really still arresting for this crime? In Texas, yes. Now, just south in Harris County, misdemeanor marijuana cases do not get filed. So it is a free for all in Harris County for misdemeanor simple possession. It's under 4 ounces. Okay. But in Montgomery County, just a little bit up the road, you could have that same marijuana and you're going to be arrested for it. Even if it looks like a lab result later on shows it's less than 0.03% THC, you're still going to be arrested. You're still going to have to go to court. Um, we are still fighting these cases up here, and most people in Harris County have not seen one of these cases in years, maybe even up to a decade now, especially at the misdemeanor level. The next most common case in Montgomery County for a misdemeanor, I think, is probably theft. A lot of times these are happening at Walmart. I think there's other thefts arrests that happen mostly at Dillard's, other stores, and things like that. Every now and then there's an employee related theft case that we'll see. But theft is a common case, and it's a lot more common when you have an attorney to be able to get that kind of a case in a position where it could be taken off your record. Even if you did it, even if you think that you're guilty of that offense, we've been successful in for people who have no criminal history, who it was sort of a momentary lapse of judgment. We have been successful in getting cases like that reduced or dismissed. There's no guarantee on these things, but I think for these very common crimes, they do see them quite a bit, and everybody does make mistakes, and it doesn't mean that your whole life is over. So definitely a theft case is something you may want to look into getting a lawyer for. Public intoxication happens a lot. In Montgomery County, the Waterway area has public intoxication arrests all the time, many times in situations where it's not really clear that the person's a danger to themselves or others, or even that they're intoxicated. We had one recently where the person was very, very low alcohol concentration and were still arrested for public intoxication. Then the last most common crime we have for misdemeanors is assault family member. This doesn't just mean members of your family like husband, wife, daughter, mother, dad. It's also dating relationships. And a lot of times these are dating relationship cases. What are the common felonies? Most common felonies are DWI third offense, assault family member, either a continuous family violence, meaning 2 instances of family member assaults within a year, or an assault family member with previous conviction. So if you have a prior deferred probation or a prior conviction for an assault family member and get arrested again, that's another likely type of crime that we'll see. Possession of a controlled substance penalty group 2. That is any type of THC vape pen. Those are being full felony arrests in Montgomery County still. Evading in a motor vehicle. That is when you basically run from the police, or we have seen a number of times where if somebody's going particularly fast and they don't notice the police behind them, it can take quite a while for them to catch up, and then they pull over immediately. There's a good chance we can defend a case like that. Also, if you have a DWI, you're too intoxicated, you don't realize that the police are following you, sometimes that can help mitigate the fact that there was running from the police. It's like, well, you didn't intend to run from the police if you didn't have any idea they were behind them. We've been successful in helping get those kind of cases reduced as well. And what are the courts? So we've got county courts 1, 4, and 5 for criminal cases in Montgomery County. County Court 1 is Judge John Hafley. County Court 4 is Echo Hudson. And County Court 5 is Keith Stewart. They are all misdemeanor court judges. These are the people that we're going to be going to if you have a misdemeanor case, a family violence case, and you need bond conditions amended. You'd like to be able to go home, talk with your wife or girlfriend or something like that, or husband, daughter, whatever the case may be. We're going to be approaching these courts on the court dates where they're open. And so there'll be times where the courts are not open or the prosecutors are not there to get agreements on these things. And so that's what we're waiting on when we have a case in Montgomery County is some of these courts. If you have a criminal case, misdemeanor in Montgomery County, it's going to be in one of these three. And the felony courts, we've got the 9th District Court with Judge Phil Grant, the 221st with Lisa Mychok, the 359th with Kathleen Hamilton, and the 435th with Patricia, I guess, McGinnis. We call her Patty McGinnis, those who know her, but now it's just Judge McGinnis. So these are the various district courts. If you have a family violence case that's a felony, these are the judges who are going to set those bond conditions. Again, if you have a case that does not have a drug aspect to it, all of these judges are going to be requiring you to appear to the bond supervision department. It's going to be like being on probation. You're going to get drug tested. That's pretty standard. Another thing is if you have a case in one of these courts and you test positive for drugs while you're on bond, in each one of them, you're likely to spend about 2 weeks in jail waiting for the judge to set a new bond in the case. Sometimes that can get reduced. We've been successful in getting that reduced for some people, especially when we have a plan of what we're going to do to try to avoid any continued drug use. But again, in Montgomery County, it's very different than in some other counties, especially Harris County. You're going to be seeing more strict enforcement of these things, and you're not going to see a whole lot of waiving of these bond conditions. So what does the judge do? A lot of people think that the most important thing about your case is which judge you get. That is not necessarily true. The prosecutor has a lot more effect on what happens. But let's talk about what the judge does do. They will set the amount of the bond. Okay. If your bond is really high, you can't afford it, you are not a flight risk, that's where we can go to the judge and say, we need a lower bond. It's not fair to hold this person in jail when they have not been proved guilty yet, just because they can't afford the bond at a certain amount. If there's no safety concerns that the judge can use to increase the bond amount, then they should lower it. Can you modify bond conditions? Yes, with the judge's permission. That's also a very judge-specific thing. That's what they can help do. And then they assess punishment. So if you have a criminal case in Texas, you can go to the judge for punishment. You can also choose to go to the jury for punishment. That is something that is left up to the client with the advice of your attorney. It depends on which court you're in. It depends the type of crime. There's a lot of things to consider with that. Talk to your attorney about what you want to do when we're talking about assessing punishment in a case. And then obviously, the number one goal for your attorney ought to be to try to get it dismissed so you don't have any assessed punishment. So what does the prosecutor do? The prosecutor is the one who works for the district attorney, the elected district attorney. Okay. In Montgomery County, they have 3 prosecutors assigned to each court: a chief, a 2, and a 3. The least serious cases get assigned to the 3. The more serious ones get assigned to the 2, and the most serious ones get assigned to the chief. In misdemeanor, nothing really gets assigned to the chief, but sometimes they hold on to some felonies when they go down. Because what will happen is they'll start in misdemeanor, they'll move up to felony, go back to misdemeanor as a chief, and then move back up to felony again. What the prosecutors do is they review the evidence in the case. They will make plea bargain offers to try to settle the case without having to go to trial. And they have the ultimate discretion to dismiss a case or not. Typically, a judge cannot dismiss a case on their own motion. There are some very rare exceptions for that, like, for example, granting a motion for speedy trial that a defense attorney has made. Basically, all they can do is suppress evidence. They can assess punishment when it's given to them, but the DA has the authority to dismiss the case. So that's the person you want to be able to convince. That's the person that your attorney needs to have an understanding of what they are doing in the courtroom. Why is the prosecutor motivated to do certain things? What type of information is going to persuade that prosecutor? That's an important thing. A lot of important things to know as a criminal defense attorney, because this is ultimately the person you have to convince to do something if you don't go to the judge or the jury. The judge can be somewhat predictable in after you've seen a number of cases go in front of them about a certain type of offense. A jury is very unpredictable. So what you want to do, if at all possible, is convince the prosecutor to see things the way that you're seeing them and get a good result. Does criminal history matter? Yes and no. In Montgomery County, it probably matters a lot more than in some other counties. But from a legal aspect, criminal history matters because it could be used to enhance your offense. For example, if you have an assault family member case, a slap on the face or a scratch on the arm or something like that, that would normally be a Class A misdemeanor. But if you have a prior conviction for assault family member, or you were on deferred probation for assault family member previously, and you pick up a new case that would be a Class A normally, well, they're going to use that prior criminal history to enhance your offense to a felony. If you have prior prison trips, 3rd-degree felony or higher, you could be enhanced from a 3rd degree to a 2nd degree to a 1st, or any one of those to a new punishment range of 25 to life if you've been to prison twice before, in what we call sequenced. That's a little bit more nuanced discussion. I'll have to do another video on that about enhancements on another time. But criminal history also matters when they look at the bond. The judge can take into account things like safety of the community, and if you have a series of violent offenses on your criminal history, they could increase your bond amount. And then finally, the prosecutor's perspective. The prosecutor is looking at these cases, and they make distinctions all the time, and they do it pretty quickly. And most of what they have at the beginning of a case is what the officer says you did and a copy of your criminal history. So it is used really frequently at the beginning of a case. It is not something that is impossible to change a prosecutor's mind throughout the case, but it is going to be a hurdle. So criminal history does matter in a case for Montgomery County, and any criminal case, really. It can be used legally for enhancements. It's going to affect your bond, and the prosecutor is definitely going to be looking at those things when deciding what to give you. So what do you do now? If you've been charged with a crime, you've bonded out of jail, the next step is you've got to find time to talk with a lawyer. You need to find somebody that you trust, somebody that has experience with the type of case that you've handled or that you're having to deal with. And you need to get a game plan together. Where are you going to be staying? How are you going to be in compliance with your bond conditions? Do you know what all of those conditions mean and what you need to do? And then the last thing is, I would say you need to be ready to be patient. These cases can last quite a long time. A misdemeanor case can be 6 months to a year. A felony case could be 2 or 3 years in some instances. the more serious the case, the longer it will take to resolve. So if you've got an assault family member case, those will take longer than a theft or a marijuana case. If you've got an aggravated robbery, that's going to take a lot longer than a possession of a vape pen. And so this has been the frequently asked questions. I hope you liked what you saw. If you liked it, click the like button, subscribe, and check out our website for more information. It's www.brianfoleylaw.com. Again, this is just for informational purposes and educational purposes. If you've got a criminal case, give us a call and we can do a consultation.